I should preface my remarks by saying, like Rajiv, I have a problem with garbled language. In my case, it's not due to jet lag, however. Just turns out I'm not very good at my job. Thank God for tenure. There are a variety of explanations for why religion has moved to the front of recent public policy debates around multiculturalism, citizenship, immigrant integration, employment equity, education, healthcare, and family law. For example, it'd be nice if this actually progressed.
By tapping it on the podium.
Sit down from there. Just stop using this technology.
All right, well, I'll let that go along.
Is it frozen maybe?
Seems to be.
There we go.
Yeah, okay. These are all my slides. If you want to wheel back here, I can simply tap on the air.
Well, you can put it on the corner of this desk, so this table would move.
Sorry, of course it worked this morning.
Yeah, that's right. We're counting these minutes.
Are you?
Bad luck.
We counted Rajiv's medical.
Do you know what?
Listen, this technology defeated you, and I told you not to use it.
Smugness is never pretty.
Always go back to the
I like the sweater, but the smug I can get
makes me look very fat.
And you're going back.
Now 15 actually.
I'm going to start again so that we have a clean video cover.
Okay.
All right. There are a variety of explanations for why religion has moved to the front of recent public policy debates around multiculturalism, citizenship, and immigrant integration, employment equity, education, healthcare, and family law. For example, Janice Grossstein suggests that Canadians face new questions because our proactive immigration policy, along with the resurgence of religious orthodoxy around the world, have brought to Canada a new generation of immigrants steeped in these forms of illiberal religion. The shallowness of Canadian multiculturalism, she argues, prevents us from asking deep and important questions about what to do when equality rights, especially the right to freedom from discrimination based on gender and sexual orientation, clash with freedom of religion, including the freedom to subscribe to and practice illiberal religion. Will Kimlicka disagrees. He argues that neither immigration nor multiculturalism is at the heart of the controversy. Instead, we have expanded our culture of equality rights, which multiculturalism policies and legislation support, beyond its original territory, i.e. government policies, laws, and practices, to public institutions, and, only recently, to free associations in civil society. Canadians, he argues, now expect religious communities to respect equality rights and to transform their beliefs, practices, institutions, and forms of community in light of them. The new controversies, he argues, simply represent another episode in the old clash between equality rights and libertas ecclesiae, the pre-modern ideas that religious communities, i.e. the church, rather than religious individuals, have rights. Now what's interesting about that debate is that neither of these individuals do any research actually on religion, on religious people, or on religious communities. By contrast, Peter Bayer does. And in his research on second-generation Muslims, Hindus, and Buddhists, Bayer sees no grounds for either of these arguments. In contrast to Stein's assertions, newcomers to Canada, he observes, adopt a variety of religious perspectives and are no more likely to be orthodox or fundamentalist than other Canadians, at least not the second generation. Very few support a politicized version of their religion, and many reject what they call religious extremism. And contrary to Kamlika's arguments, most feel that they are free to practice their religion in Canada, even though they admit certain barriers and inconveniences. His research suggests that the current debates around religious freedom, specifically reasonable accommodation, are not about religious diversity at all. So he asks, why are we talking about reasonable accommodation and religious diversity now? And he points to 4 factors. The first is a general anti-religiousness. For secular Canadians, religion was supposed to fade away as society became more rational and democratic. He writes, quote, asking the question of reasonable accommodation from such a perspective is in effect asking how much room a society should leave for the irrational and the unreasonable, and only secondarily a question of religious diversity. The second factor is prejudice, specifically anti-immigrant sentiment. In other words, Canadians are asking how to integrate the putatively inassimilable religiously other. And he writes, in this regard, old strangers, ones that were never entirely accepted, can again become the subject of concern. The third factor is Islamophobia. After 9/11, and more importantly, the attacks in Britain and Spain that followed, there is a widespread increase in suspicion about Muslim groups. And he asks if, for example, there would have been any controversy around religiously based arbitration in family law in Ontario if it had not been a Muslim group that had proposed to undertake that project. And he says, I think not. Finally, there is the question of egalitarian inclusion with regard primarily to gender. And here I think Bayer actually also forgets the second issue of gay rights and the right to same-sex unions, which is also part of that controversy. So he argues that the issue is not so much about religious diversity as it is, quote, religion as such, and what one would roughly call the social order, unquote. In other words, what is the role of religion, identified with the irrational and the unreasonable, in a society that sees reason, sometimes identified as progress, as the touchstone of its legitimacy and the ground of its public culture? In a paper that will likely see the light of day this year, in fact, in a volume edited by André Laliberté and Rajiv here, as well as Bruce Berman, that will likely see the light of day, Paul Bramadat and I contextualized this debate over social order and the role of religion in it in the evolution of the pattern of governance of religious diversity in Canada from its founding. Essentially, we argue that each social order was undermined by internal weaknesses and contradiction, as well as by changing political, social, and cultural forces. While instituting real change, each new social arrangement carried forward some elements of the previous one while introducing its own weaknesses and contradictions. As a European settler society, Canada was founded on the ideal of establishment. That is, both in its French and British iterations, the colony was supposed to mirror the ideal of the metropole, with a monopolistic church working hand in glove with the state to assure social harmony and political order. The dream of establishment, both in its French and English versions, ran into certain contradictions, most notably that the colonial governors did not have the resources to impose this social order on a dispersed and religiously diverse population. The French dream, of course, died with the British conquest, and the British project ended with the Act of Union in 1841 and the subsequent liquidation of the clergy reserves in 1854. However, disestablishment did not lead to secularism, but to what John Webster Grant has called the plural establishment, or what Paul and I simply call Christian Canada. This new arrangement carried forward some of the culture and structure of the establishment model, notably the reliance on state power to protect certain privileged Christian churches and to protect Christian values and law, but introduced the notion of religious tolerance and pluralism. This tolerance was extended to a limited number of respectable Christian groups, less so to Roman Catholics, and even less so to minority Christian groups, Mennonites, Hutterites, Doukhobors, etc., or non-Christian groups, Jews, Muslims, Hindus, Buddhists, Sikhs, etc. This arrangement was written into the fabric of Canadian society, in which a small number of Christian denominations served as a shadow establishment. Christian Canada also carried its own contradictions. The state with which the mainline churches cooperated was interested in creating larger and larger areas of public life outside of the control of the churches, most notably the free market, political life, and public institutions in the field of health, education, and social services. By 1960, the era of Christian Canada was coming to an end, leading to the formation of secular Canada, the social order rooted in the principles of secularism, according to which the state, quote, is supposed to offer equal access, equal distance, equal respect, or equal support to all religions within its territories. That's Jose Casanova speaking. If the rights of all were to be respected, then the state had to recognize both multiculturalism and secularism, including the moral equality of persons, freedom of conscience and religion, state neutrality towards religion, and the separation of church and state. Ramadat and I argue that the current social order is unstable because of its internal contradictions, including a putatively neutral public sphere, which is in fact residually Christian, the direct reliance of the state on faith-based organization to deliver services of the welfare state, as well as the soft reliance on religion in resolving disputes, promoting altruism and voluntarism, and forming citizens. And Jeremy Weber touched on some of those in his talk last night. Moreover, this new social order is ill-suited to deal with the transformation of Canada's religious landscape, including the atrophy of earlier religious identities and institutions, the individualization and subjectivation of religion, and the religious diversity introduced by our proactive immigration policy. We interpret the current uneasiness around issues of reasonable accommodation, immigrant integration, religious intolerance and discrimination, as well as these larger issues of religion and citizenship, healthcare, education, etc., as signs of the fact that we now live in an interregnum. The metaphor is Paul's, not mine. He's in charge of the metaphors of all of our writing. A transition from a secular to a post-secular order. And what would a post-secular order look like, or what does it involve? In very broad strokes, partly we can't know what a post-secular order looks like because we're not living in one yet. One where the public sphere is open to participation by religious groups on their own terms, an observation that Jürgen Habermas or a conclusion that Jürgen Habermas has come to after many decades of saying the opposite. A state of twin toleration, where secular actors and the state recognize the legitimacy of religious communities, and in return, religious communities recognize the neutrality of the state towards religions and each other as legitimate actors in society. And finally, the fact that the secular actors and institutions adopt a denominational rather than a sectarian stance. Thank God Paul held up the stop sign. I hope I have 5 minutes. Basically what I want to talk about in this paper, or I want to introduce anyway as a topic, is how the Ontario Human Rights Commission's creation of a policy on balancing competing rights, as well as its effort to define its policy on the protection of creeds, are signs of this interregnum between a secular and post-secular Canada. And so let me move on very quickly to them. The Ontario Human Rights Commission is one of 3 bodies that oversees the human rights in Ontario. And the tribunals make the actual decisions, but the Ontario Human Rights Commission is in charge of education, developing policy, and even bringing cases to the various tribunals. The first policy was on competing human rights. which was launched by a framework paper in 2005. It was followed by a conference in 2010 and an issue of Canadian Diversity in 2011, a journal by the Association of Canadian Studies. The concept involves a state where one has two rights that are recognized by the Charter or established by the Ontario Human Rights Act that conflict. The basic principles is that there is no hierarchy of rights. There's no automatically saying one right is more important than the other, and that these have to be decided on a case-by-case basis. This is how the Ontario Human Rights, these are the parameters under which the Ontario Human Rights Commission approached this question of competing rights. Now, it shows examples of competing rights and where the rights are situated and where they might come into conflict. But in case you're wondering what the source of the tension that gave rise to this new concern is, you may note that 6 of the 7 examples in the final policy paper of competing rights involve cases where religious freedom competes with equality rights. For example, a civil marriage counselor who objects to performing a marriage ceremony for a same-sex couple, claiming that it violates his religious beliefs. A born-again Christian who repeatedly encourages his employees to attend his church. And a Jewish family who is told to remove a temporary sukkah hut from their condominium balcony for a religious celebration, but which interferes with their neighbors' enjoyment of their balconies. These are all cases, examples that were taken from recent conflicts from competing rights that the Canadian courts have faced. The second project, and one that I've been involved with, is the new policy on discrimination based on creed. According to the OHRC, this policy update, quote, will draw on lessons learned from the OHRC's recent work on a competing rights policy. In other words, the two projects are connected. The policy update began in 2011, so this is very fresh. And in January and March of this year, 2 conferences were organized at the University of Toronto and York University's Osgoode Hall. Again, the papers of the Toronto conference were published in a special issue of Canadian Diversity. After a series of public consultations, the policy will be updated in 2013 or 14, hopefully before the deadlines of the publications from this conference's proceedings. In fact, the last update I got was from Remy Warner just on Wednesday before coming to this conference, flying later that day to this conference. So I'm going to go through quickly so they're updating a policy on creed that is only 15 years old. And when I read the 1996 policy on creed, I was actually rather pleasantly surprised by its sophistication and its generosity. So I asked myself, why did the Commission feel it necessary to update the code it had adopted only 15 years earlier? There are a number of issues, most notably arising from various court decisions. And so the earlier policy discussion on competing rights was started off by a framework discussion. This policy review started off with a case study review, rather extensive and excellent one, I might add. So this project is driven by court decisions, i.e. changing thinking about equality rights. So Kimlicka was partly right. It is inspired by the changing Canadian religious landscape. In other words, Janice Gross-Stein was partly right. And also by scholarship on religious diversity. The problem, and well, I'm going to go through one last one. I'm going to beg Paul's forgiveness, and that is simply about making a connection to Rajiv's talk earlier this morning, and simply that one of the things that the Commission is rethinking, one of the reasons why it's rethinking its policy on creed is the fact that it is dealing with a changing definition of creed. And just as Rajiv said, we have to move past a definition of creed which is based on a Western conceptualization. The Commission is wondering how it can, in a liberal democratic regime, protect a broader array of religious freedoms based on a broader definition of religion. And it's a broader definition of religion which is more appropriate to a more diverse and, I would argue, a more post-secular Canada. Thank you.